Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors. Let us take care of probate.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello again to our viewers, wherever you're watching from in the world. We give you a big December greeting. Welcome to our new month. As we're getting closer to Christmas, I hope that we are all doing well and that by God's grace, everything is going on well. As we do every week, you can see that I'm hosting today, but I will not be the main host for today. Later on, you will have one of our well known guests come and join us. And so, before we introduce her, I'll give a few updates and then I will share what our nugget is for this week. And so, in terms of our usual updates, there has been a lot that has gone on in the, should I say, news. And I think that a lot of viewers would have to know in regards to what is going on. We've been speaking a lot about the e-visa, which is your electronic version of your immigration status. And so everyone in the UK who holds an immigration status, which is not a British citizen, whether you are an EU national or non EU national who has leave to remain in the UK or indefinite leave to remain in the UK, you will hold some form of electronic version of your immigration status. Those who are under the EU settlement scheme, which is the people who are EU nationals and their family members, they are already on the e-visa scheme because they are under the EU settlement scheme. And so they are able to view their status online. They're able to share the code with employers, with landlords, and other agencies that need to see their immigration status. But when it comes to those who are not EU nationals or EU family members, this is what the government has now rolled out for all those who are non EU nationals. And so as we have been told before, they said previously that the deadline to enroll your e-visa was the 31st of December 2024. As people are still having issues with the e-visa, they have now rolled it over to March of 2025. So as you can see on the screen, the government have postponed the transition to e-visas because of system failures. And so hopefully they are going to review the new deadline of March 2025 and see how many people have been able to transition from the physical document or from the biometric card to the electronic immigration status, which is the e-visa. And so, as many people as possible should make well and do well to make sure that they have now um, put their details onto the UKVI account. So, they've asked people to register onto the UKVI account. And then, once you've registered onto the UKVI account, you will then be able to have your immigration status viewed on there. And most people who are able to register onto the UKVI account are those with a biometric card. And so, if you are somebody who was given indefinite leave to remain either in your passport or on a sheet called a RON 60, then you would have to now apply for NTL e visa. So, an NTL application is a no time limit application for those who have indefinite leave to remain in the United Kingdom. Once you have been able to apply for an NTL e visa, you can have your biometrics taken at the usual centers, and then a code will be given to you, which you would use to enroll onto the UKVI account, and then you would be able to view your e-visa that way. The government have already started rolling it out for those who do not even have a biometric card at the moment. So they stopped issuing biometric cards from the 31st of October. And so those people who do not have biometric cards are now given a code and they are able to use that code to now enroll onto the e-visa or enroll onto the UKVI government account. And so that is that in terms of e-visa applications that are currently being made. And then, secondly, we have the fact that the Home Office have now intensified their checks on those who are hiring illegal immigrants. And so the government have realized that there has been an increase in the number of migrants that have come through since um, the Home Office opened up the system to let more people from outside of the EU come into the UK. And because there has been, a, should I say, more of an increase in the past few years in terms of migrants coming into the UK, they have said that they are going to intensify their checks with employers who are hiring employees who may have illegal stay in the UK. And so, as you can see on the screen, there have been checks done at nail bars. You see that nail bars and then mechanics and other, should I say, workplaces where the employers may seem to have hired people that are working illegally. And in so doing, they have found that there are some scrupulous employers who are taking in employees and are abusing the system. And so, obviously, if they do find out that you are an employer who is hiring an employee who is here illegally, then you would then have to pay a fine. And that fine is currently standing at 20,000 per employee that is seen to be illegal if your fine is not paid in time. So the liability is at 10,000. If you're not paying in time, it rises to 20,000 per employee. And that is a lot of money to be paying for just one employee. So can you imagine if you are hiring 4 or 5 employees that are not should I say, do not have legal standing in the UK. And that in turn will also affect the business. So that means that businesses are less likely to stand if that is the amount of money they have to be paying out to the government. And there are some who have sponsor licenses that will be revoked. And if the government come and do their checks with your business and they find out that you are hiring somebody who is here illegally or you are abusing the system, you are not following the conditions to your license, they are likely to revoke your license or suspend your license as an employer because you have not complied with the conditions that were given when they gave you that sponsor license as well. So this is a call out to all employers who are hiring employees who do not have immigration status currently or who in one way or the other may be abusing the system. They truly want to crack down on illegal migrants remaining in the UK and have said that they are not going to follow on with the previous government's Rwandan, should I say, idea to take illegal immigrants from the UK to Rwanda, and they believe that that money could go towards other things, such as the economy in the UK. And so, therefore, if you are found to be working here in the UK illegally, they are more likely to return you to your country of origin rather than to send you back to Rwanda, as the previous government laid out. They would not do so and would rather remove you to your country of origin. And so, this is a word of caution to our employers out there to make the right decisions and put things rightly so that you are not found out to be holding or to be enrolling illegal immigrants at your workplace. And then, third but not least, we are going to be talking about the fact that we have our ETA, which is the Electronic Travel Authorization. So, those who are countries that usually do not need visas to come and visit in the UK are countries such as Canada, the USA, New Zealand, Australia. Most European countries don't need visas to come into the UK. Most of the Southern American countries, such as Venezuela, Colombia actually now needs a visa. They should I say, changed them from a non-visa country to a visa country just recently, and there was an uproar about it because they felt that they should still be a non-visa country when it comes to visits to the UK. And so most countries that are known to have good standing with the UK would tend not to have to apply for a visa when you are coming on a visit. When it comes to countries such as the USA and Canada and Australia, some of those countries already have ETAs that they apply to UK citizens. And so, therefore, the UK has also come up with the idea of now having an electronic travel authorization, which they would have to apply for in their country of origin at least 72 hours before travel to the UK. And they would need to pay £10 at least for the ETA. And the ETA is most likely to last for about 2 years. And so once you've applied for an ETA, whenever you're traveling to the UK, you can use the one you applied for, and it will last you for 2 years maximum. And for most countries within the UK, I mean, within the EU, that will be enrolled by the 2nd of April. And so any countries such as Romania, France, Spain, Netherlands, most EU countries would need to apply for an ETA whenever they're coming to the UK from the 2nd of April 2025. All non-European countries will need to do so by the 8th of January. So if you're a non-EU country and you want to come and visit the UK, you would need to apply for an ETA, and that should be done by the 8th of January 2025. And so obviously most people will be coming to the UK for tourism, for other visits such as family and the like. And so obviously if you believe that from next year you are likely to come and visit the UK, please do make sure that you have applied for an electronic travel authorization, which is only £10, and that should cover you for 2 years. And so I'll leave our updates here. We'll go for a short break, and then when we come back, we'll have a look at the nuggets, and then we'll introduce our guest for today.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Okay, so we're back again, and as we do every week, we have our nugget for the week, and hopefully by the end of the program, we will be putting out the questions and we'll be asking viewers to take part in our quiz. I can see that we have people that have joined the program. I'd like to give a shout out to Tilly Duma. Thank you so much, Tilly. She says, please kindly share, comment, and like. Thank you. Thank you so much, Tilly. We are grateful. Uh, Mr. Samuel Ochre, 470 says, great job. Thank you so much, Mr. Samuel Ochre. And we have our very own Sandra Fraser. And she says, good evening, lawyers Eunice and Annie. Thank you so much, Sandra. She's put out the contact details and everything that you need to know in terms of contacting BWF solicitors. We are so grateful for your patronage, Sandra. Yes, and I know that there are more viewers to come, and I look forward to seeing you all. Lily Soa is saying, good evening, Lawyer Eunice and Lawyer Annie. Thank you so much, Lily Soa. We are so grateful. There are more of you watching behind the scenes, and we are so grateful for your patronage this evening. I know that our very own country, Ghana, is also having elections today. We wish them the very best of elections, wishing them the peace of God so that everything goes as peacefully as possible. And so, if you're voting in Ghana today, we would like to extend our warmest greetings, and we hope that the elections go smoothly in Jesus' name. Okay, so coming back to our nugget for the week. Yes, so I know that a lot of us look forward to the nuggets and we like to test your legal knowledge. And so hopefully this week we'll have a lot of people knowing the answer to our question. So when you look at our screen, our nugget is to do with fee waiver or change of circumstance conditions. And so it says that when applying for a fee waiver or change in circumstance condition, the Home Office must be satisfied that the third party support you rely on has provided evidence of their means and income, including 6 months bank statements with explanation of all entries over £100. Most third party support providers do not appreciate being asked to disclose their private information when they are not the main applicant. Therefore, always disclose to the support provider that they would be called upon to provide private information and evidence. This was the decision in SAG and others against the Secretary of State for the Home Department 2024. There is not therefore anything unlawful or irrational or irrelevant in asking for further evidence from the third party supporter. And to give some more detail to this, in terms of fee waiver applications, fee waiver applications have to do with people who may be applying for leave to remain in the UK, many based on human rights applications, and they are telling the Home Office that they do not have the means, they do not have the money to pay for the Home Office fees and to pay for the immigration health surcharge. This could be in regards to an in country application or an out of country application. And so, if you are making an application and mainly it is a human rights application, you can apply for a fee waiver. And most of the time, once you've applied for a fee waiver, they will require evidence of your income and expenses. If you are saying to the Home Office that I am not working and therefore I rely on a third party for income to be able to look after myself and maybe my child or my children, the Home Office is going to require the third party who is providing you financial support to also provide evidence of their bank statements and pay slips for that 6 month period. And so let the person who is providing you with financial support know that this is a requirement from the Home Office, and it is part of their guidance or their policy to require such information so that they are sure that there is no means by which you can pay for the Home Office fee or the immigration health surcharge. And also, when it comes to change in circumstance, usually if you have lived here for some time and you believe that because your immigration status or the leave that you have been granted carries no recourse to public funds, and therefore you are in a circumstance or you're in a situation where your income is less and your expenses are high, and you would not be able to sustain yourself and your children or your family, then you can apply to the Home Office for a change of circumstance so that the no recourse to public funds condition is lifted from your leave. And if you are applying for a change of circumstance, you will also need to provide evidence of your income and expenses. And therefore, if you are also saying that a third party is supporting you in that regard, then they would need evidence of that third party's pay slips and bank statements to show that indeed they do not have the funds to support you as they have always done. And so it is important that once somebody is said to be supporting you financially, they too will also have to provide evidence of their income, their pay slips, their bank statements for that 6 month period. And if they are providing you with accommodation, evidence of the accommodation as well. And if they think that is too much, then you should let them know beforehand before you make the application so that they are aware that this is a requirement by the Home Office, so that they know that this person is the person supporting you financially. And if it means that they don't have the means to support you in paying for the Home Office fees or paying for the immigration health surcharge or supporting you financially as they have always done, then the Home Office can now waive the fee or lift that ban for no recourse to public funds. So it's important that you let them know that this is a requirement, not just by the Home Office policy, but now we have it in case law. And this case law is now setting precedent for those who support applicants financially as well. So please bear this in mind whenever applying for a fee waiver or when applying for a change of conditions, so that the third party knows that it is a requirement for them to also supply all evidence of their income when making this application. Okay, so now that we have briefly spoken about our nuggets, I would like to introduce our guest for today, our lawyer and solicitor and sister, lawyer Annie Akofio Soa, to today's program.
Hello, good afternoon, Lawyer Eunice.
I
Thank you
hope
for
you're
that
doing
warm
well.
welcome. I'm good, thank you. How are you?
I'm doing very well. You look
Great.
very, very smart and
Oh,
beautiful.
thank you very much. Yes, so welcome to all our viewers. Thank you for joining us today. We're grateful to have you here with us this afternoon. So, the topic for today is: can I apply for indefinite leave to remain if I am emotionally and economically abused? And I think the reason why this topic is quite important is because there are, first of all, some misconceptions which we will deal with today. So, first of all, when it comes to domestic abuse, I think that as a society, we tend to think that it's only women who go through domestic abuse, but of course, men go through domestic abuse as well. So, also when it comes to domestic abuse, when we normally think about it, we think of perhaps physical abuse, but there is so much more. You can rely on that to apply for indefinite leave to remain. So you don't have to necessarily be physically abused. So before we delve into the topic further, it's important to kind of set the scene. So, what is domestic abuse to begin with? I mean, it's such a huge topic in itself, but I think it's quite well defined in legislation. So, Section 1, Subsection 2 of the Domestic Abuse Act 2021 defines what domestic abuse is. So it says that the behavior of person A towards person B will amount to domestic abuse if the both of them are over the age of 16, if they are personally connected, and thirdly, if there is abuse. So, what does it mean for them to be personally connected? So, if you are married to the person, you will be personally connected to them, or if you are in an intimate relationship, you'd be connected to them as well. And in terms of abuse, as I've kind of hinted, it's not just physical abuse, there's so much more. But in terms of physical abuse, if you are living with your partner, let's say, and they are hitting you, slapping you, pushing you towards the wall, shoving you, or burning you. I mean, there are serious instances, or if they are choking you, all of that would fall under physical abuse. But there is more. So we have emotional abuse, which can include blackmail, or if your partner is ignoring you, giving you silent treatment, or they are threatening you in any way, cursing you, insulting you, all of that would fall under emotional abuse. Then we also have financial abuse. Let's say partner A and partner B, they have a shared account. If partner A prevents partner B from using money within that account, that would be classified as economic or financial abuse. Or even if they have two separate accounts and partner A uses partner B's bank account without partner B giving consent, that too would fall under economic abuse. And we lastly have sexual abuse. So that is can happen even within marriage, where, for example, partner A rapes partner B. So that is when anything happens that is not consensual, or the person partner A takes pictures of partner B and they, for example, inappropriate pictures to an extent, and they share those pictures with other people. So that would fall under sexual abuse. So I just want to repeat that when it comes to domestic abuse, it's not just physical abuse. I think that's what comes to mind quite often, but there's so much more. We have emotional abuse, sexual abuse, and also financial abuse. So the Home Office, they have come up with a concession for people who are here in the UK, and they, let's say, the partner entered the UK based on their relationship with someone who is here, let's say a British citizen, And let's say the person now enters the UK, and then all of a sudden their partner starts emotionally abusing them or economically abusing them. The Home Office is of the view that a person in such a situation doesn't have to die within that relationship. So they have come up with a migrant victims of domestic abuse concession. And the concession basically allows a victim of domestic abuse to be separated from their partner for at least 3 months. So that means that their status here in the UK wouldn't be dependent on their partner no longer. They would be separated from their partner. And within that 3 month period, they would have access to public funds, because normally when people come to the UK under the partner route, it's not automatic that they would have um, recourse to public funds. But if they apply for the concession and it's successful, the person would have access to public funds. And within the 3 month period, there are three options that are available to the victim. So either they can switch to a different route. What does that mean? So let's say partner B came to the UK on the partner route to join their partner A, and they have a child together. So let's say the person who lives here in the UK is British and they have a child together. In that case, the child would be British, especially if let's say it's the father or the man is a British citizen. If the woman were to give birth, then the child too would be British. So in that case, the woman could put in an application, FLRFP application, based on her relationship with a qualifying child, which in this case would be her British child. Another option that the victim could go through within the 3 month period that the Home Office will give them is that they can put in a set DV, so set domestic violence application, which is what we're going to deal with today, really. Or the third option is that they can leave the UK. So I'll just ask my producer to put up the concession so that we can have a look at it and that we can go through it. So this is version, this was updated on the 31st of October 2024, and it's the Migrant Victims of Domestic Abuse Concession, which was previously known as the Destitute Domestic Violence Concession. So before it was changed, the victim would have to prove that they were destitute, which basically means that they had to prove that they didn't have adequate accommodation, or that they did have adequate accommodation but they couldn't meet their essential living needs. But now that the concession has been changed, they no longer have to prove destitution, which is great. So when it comes to applying for the concession, this is the form that you would use, which you can just find online. And yeah, producer, please, if you just stay where you are, if you scroll a bit, yeah, that's perfect. Thank you very much. So this form is specifically for those who have been granted leave to be in the UK under specific routes. So the first one is that you must have, you must be a partner under Appendix FM of a person who is either a British citizen, whether they are British from birth or by naturalization, or your partner can be settled in the UK, which means that they can have indefinite leave to remain, or they can have limited leave to remain under Appendix EU. Another option is that you could be a spouse or a civil partner or a durable partner under Appendix EU with a limited leave to enter or remain as a family member of a relevant EEA citizen. So if you don't find yourself in those two sections, that's okay. There's more. So you can be a partner under Appendix FM of a person who is here as a refugee. So if your partner is here as a refugee and you put in an application to join them and they're abusing you, you can use this concession as well. You can also be a partner of a person who is present and settled in the UK under paragraph 285, or if you are a victim of domestic abuse under Appendix FM, you can also fill out this form. Or even if you are a partner of someone, a member of the armed forces, and you have suffered domestic abuse, you can fill out this form as well. And lastly, if you are a partner of a person who is here in the UK, either as a student or they're here on a work route, such as, for example, they're here as a skilled worker, then you can fill out this form again if you are experiencing domestic abuse. So, what is really important is that you have to show that your relationship broke down. And relationships break down for various reasons. So, here in this case, you'd have to show that your relationship broke down as a result of domestic abuse. So you kind of have to show causation. So what that means is that you have to show that the relationship broke down as a result of domestic abuse. When it comes to the application, the caseworker, they will kind of look at a test, and the test is known as the test of probability. So they will look whether, on the basis of probability, it is more likely than not that your relationship broke down as a result of domestic abuse. So, producer, if you could kindly just go back to the application form. Thank you very much. So if you just scroll down, yeah, please keep going. Thank you very much. That's fine. So once you complete this form, you can either email it to the Home Office, and the email address is just there. So the email is domesticviolence2 at homeoffice.gov.uk, or you could post it to them. You could post it to the DV duty officer. So I just want to go through the application because I want to show you that it's not a complicated application at all, because I think some people, when applications seem to be too complicated, it kind of puts them off from even starting with the whole application. So let's go through the application. It's quite straightforward. So as you can see in section 1.1, you just have to put down your given name. So that's your first name, any middle names, and your family name. So it's important that the names that you put down are the names as it appears on your passport or your travel documents. And in 1.2, it will ask you whether you've been ever known by any other name. So if, let's say, you're married and your name has changed, then you would click yes, and you'd put down your maiden name. Or even if you changed your name at some point using a deed poll, again, you click yes, and you put your previous name down in the application. It will also ask you for your date of birth, which you would just put in there, your sex, where you were born, what country you were born in, what town you were born in. You'd also include your nationality and your passport number if known. Then it will ask you in 1.9 whether your relationship with your partner, let's say your spouse, has broken down because of domestic abuse. And the answer should really be yes, because that's the whole point of this concession. Your relationship should have broken down due to domestic abuse. If it had broken down for another reason, then this is not the type of route for you to explore. So in under normal circumstances, you would click yes, your relationship broke down due to domestic abuse or as a result of domestic abuse. It will then ask you whether you need permission to stay in the UK that is independent from your partner. And again, normally you would click yes. And it will ask you whether you wish to access public funds within the 3-month period. And normally that too would be yes. The answer would be yes. Yes, so then it will just ask you about your contact details, your email address. You'd have to confirm your email address. your telephone number, you'd have to put that down as well. Your postal address, so you can put there your, it depends if you are represented. So let's say you don't have representation, you don't have a legal representative acting for you, then you just put in your home address, your door number, street name, town, county, and postcode. If we just scroll further down, is this where you live? Yes. And then if you just scroll further down, you'd be asked when you started living at this address, and it will ask you whether you and your abuser live at the same address. So the answer would be yes or no, depending on your circumstance, really. And then it will just ask you information about your partner, your spouse, your abuser. You'd put in again their name, first name, middle name, their family name, their date of birth, their sex, whether it's female or male. You'd put the country that they were born in. So you can see from this that the application form is not difficult at all to fill out. So Adai, please keep going. It's quite self-explanatory. If there are any children involved who you want to be included under the concession, you'd put in their details as well. And I think the Home Office, they have done quite well. They have left spaces for like 3 children. Like let's say if you have 3 children, you can put all of their details there. And even if you have more children, there is space at the end of the application to put those details there. And then if you have, a legal representative, section 5 is what you'd have to fill out. So you'd put in your legal representative's name, given name, let's say Bernard, family name, Owusu. It will ask you the firm, the name of the firm. So BWF Solicitors, you'd put their contact details there, their email, and their telephone number. So it's quite a straightforward form. Thank you very much, Adai, for that. So once you put in the concession, it will be with the caseworker, and the caseworker will decide whether, on the balance of probability, it is more likely than not that your relationship has broken down as a result of domestic abuse. And if they think that it is more likely than not, then the concession will be successful. So as I said, you'll be given 3 months leave, which is separate from the leave of your abuser, which means that you no longer have to rely on him or her or them. And you would have access to public funds. You would also be able to have access to accommodation, free accommodation, which you do not necessarily have to pay for. So that's all good. And as I said, within the 3 months, you have to make sure that you don't just sit idly. You have to decide what the action plan is in terms of moving forward. Are you switching to a different route? Are you putting in a set DV application, or are you leaving the UK? So we are specifically looking today at the set DV application. So Adai, if you could please put up appendix victim of domestic abuse. Thank you very much. And we're just going to look at the requirements for this type of application. So in terms of the validity requirements, if you just scroll down, Adai. So what are validity requirements? Validity requirements are requirements that have to be met before for an application to be valid. So that means that if you do not meet all of the requirements that I'm about to go through, then your application will not be valid. It will not even be considered. It will just be rejected. So Ada, if you just scroll further down, please. Yes, so you would have to fill out the specified form, which means that you have to fill out the correct form, which you can find on the gov.uk website. So that is set DV application. That's the name of the form. You have to make sure that you fill out the correct form, because if you don't fill out the correct form, that will lead you to a different route altogether. You then have to make sure that you pay any fee. I mean, if the concession, for example, wasn't granted, or you don't have a fee waiver, in that case, you'd have to pay the application fee. You would have to also get your biometrics taken, whereby you go to a visa application center and they would take your biometrics. And normally, how it works is that you have to your biometrics have to be taken at least 45 days after you have submitted the application, because if you do not go for a biometric appointment within that time frame, then normally the Home Office, they come back to say that your application is not valid because you did not attend a biometric appointment. And then lastly, you have to provide a passport or some sort of identity document that satisfactorily shows your identity or your nationality. And as it says in VDA 1.4, if an application does not meet these validity requirements, then your application may be rejected as invalid and it will not be considered. So that's number one. These are the validity requirements that have to be met. Then number two, we have suitability requirements, as you can see in VDA 2.1. So suitability requirements, basically what that means is that you have to show that you are a person of good character or conduct. So you have to basically make sure that you haven't overstayed in the UK and that you have not breached any conditions that are attached to your permission. And as you can see, it mentions part 9. Um, so what that basically is that you have to make sure that in any previous applications that you have submitted, that you haven't provided any false information, that you haven't provided any fake documents as well. And then if you just scroll down, please, Adai, to the relationship requirements. Yes, please. VDA 4.1. So we already dealt with these, but you have to make sure that you are a partner, that your partner is within one of these different sections. Because let's say you're here and your partner is a visitor, then clearly this is not the route that you would explore. So you have to make sure that your partner is either British. I mean, you can see the requirements there. So make sure that your partner at least falls within one of these criteria, that they're British or that they're here, um, that they have limited leave under Appendix EU, or that they have indefinite leave to remain in the UK. And Adai, if you just scroll down, thank you very much. Keep going, please. Thank you. Yes. So again, you have to show that the relationship broke down as a result of domestic abuse. So those are the requirements when it comes to the application. Now, in terms of the documents that you would provide for the application, you would have to basically show that domestic abuse took place. So the type of documents that you provide will depend on the abuse that you went through. So let's say you're a victim of physical abuse, then you'd provide police reports. So let's say your partner abused you, they slapped you, or they shoved you into a wall at some point, and the police was called to the incident, then normally they would take, a statement from you. They would write a police report. So you could rely on that report as part of your application, because you honestly, it's not good enough just to submit the application. You need evidence to the effect that you are a victim of domestic abuse. Or even if you have medical reports, that too would be helpful. So let's say your partner physically abused you and you had wounds or you had cuts, and you went to your GP to get stitches. You could potentially ask for a letter from your GP, for them to provide you with a letter to kind of attest to the fact that you had injuries which were consistent with domestic abuse. And if you had in place or have in place a non-molestation order, that too, you could rely on that, because when it comes to non-molestation orders, it's where someone, a victim of domestic abuse, they apply to the court for the court to basically prevent their abuser from hurting them any further. So someone wouldn't have a non-molestation order really if they're not a victim of domestic abuse. So you could rely on all of that. Honestly, the more the better. Even if you have pictures of bruises, cuts, a broken arm, any type of injury that you have experienced, you can rely on pictures if you have those. And then when it comes to emotional abuse, that one perhaps is more difficult to prove that you are a victim of emotional abuse, but it's still possible. Let's say your partner insults you, or they have sent you threatening texts, whether it's direct messages or on WhatsApp or on social media. You can take screenshots of those texts. That's no problem at all. And you can rely on that. You can submit it as part of your application. Or even if you have, because of your abuser's behavior, you have been diagnosed with depression and your doctor has put you on antidepressants, you can even take pictures of the box of the antidepressants, and you can upload that as part of your application. And if you have been involved with any type of agencies that help with domestic abuse, such as Women's Aid, and of course there are some agencies out there also for men. If you have been in touch with any of them at all, if they have provided you with housing at any point, you can ask them to write a letter, because honestly, the more evidence that you have, the better. Thank you, Lawyer Eunice.
Okay, thank you to Lawyer Annie. You went into a lot of the issues that our potential clients may be facing. I'll let us go on a short break, and I have some few questions here that we could go
Guys,
through
I
when
could hear
we
you
come back
saying.
from our short break. So we'll come back shortly, viewers. Give us a few moments, and we'll be shortly be with you.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Okay, so we have Pamela here with us, so she will be helping us with our question and answer session. Just before we went on our break, Annie was speaking to us on the question of can I apply for indefinite leave to remain based on me going through domestic abuse, whether it was economically or emotionally. She mentioned a few things, and then I wanted us to just elaborate on it a bit so that we could truly understand who can make this application and on what basis uh, a person in this situation could make such an application. So, Annie, I thank you so much for elaborating so much on the topic and giving us the know-hows in terms of how to make an application for concession and how to make an application on the basis of domestic abuse. You did mention that as a result of the Domestic Abuse Act of 2021, there are certain categories of abuse that will be considered to be abuse, and formally would say that somebody who was physically abused is somebody who is truly uh, been through some sort of domestic violence, and it was previously known as domestic violence before, but now we have a much broader definition of domestic abuse, which also constitutes emotional abuse. It also constitutes economic abuse or controlling and coercive behavior. I just wanted you to really touch on what does it mean to be economically abused. What does that mean? Can you give us some examples of that? And if somebody is in this situation, how would they term this as abuse and then say that they could make an application on that basis?
Your question. So when it comes to economic abuse, what is it? It's when, let's say, partner A, there's partner A, we have partner A and partner B, and partner A is taking advantage of their partner when it comes to finances in particular. So instead of saying economic abuse, we could also say financial abuse. So an example that honestly comes to mind is if they have a shared bank account and their partner prevents them from even using money, like, or having access to that account in general, because when it comes to abuse, some people, they like to be in total control of their partner. They don't want their partner to be able to do anything else without them, and so their partner might prevent them from having access to that account in total, or they might prevent them from, yeah, using money. Or another example would be that their partner would take the other partner's bank account and just be spending it on for themselves without their partner giving consent to that. So that is what economic or financial abuse really is.
Wow. And this also goes to show that this could be something that is a systematic form of behavior. So if somebody um, is probably sharing an account with their partner and they can draw money out at any point in time, so it might be that the main applicant is the one who is always working but has nothing to show for it because the other partner is always drawing money out for one reason or the other. And I like the second example that you gave in regards to even it being your independent account. And because the second party has access to your account, they can use your card at any point in time, or they can even go into your online banking and withdraw money at any point in time. And so, obviously, when something like this happens, how is it possible for the party who is the victim to show evidence that this is what is happening? Because as we are speaking now, for instance, if the person is having an independent account and the second party is withdrawing money from the account as if they were the victim, it will be quite difficult to show this in a form of evidence. Is it possible to show that this is happening? Is there a way that they can show that this is something that they have been through? Is there a way that they can evidence this?
Yeah, so when it comes to the evidence in relation to financial or economic abuse, it's not as straightforward as, let's say, physical abuse or perhaps emotional abuse. So, I mean, in terms of the evidence, the victim can put forward a witness statement and they can write their their story. Really, they can explain that their partner uses their bank account details without their consent, or that their partner prevents them from having access or using the money in their shared account. So honestly, a witness statement, the court or the home office, they would place evidence, or they would actually rely on that type of evidence. Or even if the victim has family and friends who are aware of this situation, they could also write supporting statements to attest to the fact that the victim is going through economic abuse.
Oh, that's a very, very good point to make in terms of the statement and the fact that third parties can also put forward statements to show that this is what has been going on. And I believe that if there are children within the family unit, they are very, very good representations of what is actually happening. And if for one reason or the other, this is something that they have mentioned within their school settings, you would be rest assured that the school would have transferred or referred this case to social services, who would also come into the picture and will also take statements and may assess the family on the basis of what is happening within the family unit. So it's good that at least there are support systems where they can also go and then make their voice heard. I also like the fact that you mentioned that as a result of appendix domestic violence or domestic abuse, we now have applications that can be made on behalf of the child as well, who may be relying on this same partner for their leave to remain. In previous applications, it was just the partner of the person who has abused them who would be able to make this application. But we have this new category of children who are part of the family who are now able to make applications under domestic abuse. And that is something I'm hearing that, I mean, for the very first time. And so, could you please shed a bit more light in terms of the requirements that will be needed in terms of um, maybe this victim and the child in particular who may be making this application?
Yes, please. So when it comes to children, the child does not necessarily have to, let's say, physical abuse. The child doesn't necessarily have to be hit in order for them to be able to rely on the concession. So even if the child hears or sees the parent, let's say the mother or the father, being hit, the child on that basis would be a victim of domestic abuse as well. So I just want to make that clear, that the child doesn't actually have to be like punched, for example, for them to be a victim. But by them actually seeing the other parent being a victim, actually being hurt, they can be a victim as well. So when it comes to the concession, the migrant victims of domestic abuse concession, as we saw earlier, if a parent is completing the application, there's a section for children as well. So if the parent wishes to add the child to the concession, they would put in the child's details: first name, last name, their date of birth, and just the relevant details. And in that case, the child would also receive leave that is separate from their parents, and they would have 3 months to move to a separate route.
Okay, thank you. So, in terms of the concession, does that mean that they've made the application, or does that mean that it gives them ample time to now make the application within the 3 months?
Yeah, so after the concession, that's when they would make the other application, whether that's the set DV application. So normally, the reason why they go for the concession is because it's a type of fee waiver, because you can either pay for the set DV application or not. So when you put in the concession and it's successful, you don't have to pay for the set DV application. Yeah.
Okay. Thank you so
Yeah.
much for explaining that in a lot more detail, Lawyer Annie. So I know that our viewers will like to ask their questions. It doesn't have to be on this topic. We're going to open up the phone lines, and our producer will put down their numbers on the screen where you can call and you can ask your questions either based on this topic or any other issues that you may have. I believe that the number to call is 0208 493 7345. So 0208 493 7345. You can call on the studio number, which is on your screen now, and I believe that whatever questions that you may have, we would be able to answer. I believe there are some questions that have been put on the platform as well, and so we'll take those questions as well.
Thank you very much, Lawyer Eunice and Annie. It's another Saturday. We've had a very, very interesting topic today. And as you have realized by now, we have had two very knowledgeable solicitors from BWF Solicitors, Lawyer Eunice and Lawyer Annie, to take you through whether you can apply for indefinite leave to remain in the UK if you have been emotionally and economically abused. Just as Lawyer Eunice said, we are opening the phone lines so you could call and ask your questions. You could also ask your questions down in the comment section and we will read it out for Lawyer Eunice to provide you answers to that. The studio number is 0208 493 7345. The studio number is 0208 493 7340. Please call if you have any question for Lawyer Eunice. We'll also look at our quiz for the week, which was based on our nuggets for the week shortly. So we are going to take some of the questions from the comment sections. So we've got our first question from Benjamin Marcoy. He's asking, please, if you are a skilled worker and your sponsor has no job for you to do, what can you do to avoid future challenges during renewal? Lawyer Eunice, can you kindly help us with Benjamin's question?
So here we have a skilled worker who has come, and his employer unfortunately hasn't got work for him. And he's thinking, how then am I going to be able to renew my visa if I have no work to do? I don't know what route or on what basis Mr. Markwell is in the country, but if for one reason or the other he is able to switch, I would say that switching to another employer may be the best option. Because when you are going to renew your visa, they would require evidence to show that you have been granted a new COS. So you should be granted a COS which states the term of your job role, what your job role will be, how much you'll be paid. And if it is from the same employer, then they would also expect that you will meet not just the COS requirement, but you also be able to meet the salary requirement. You will also be able to meet the English language requirement, which you've already met beforehand. And if they are choosing to maintain you, then they must show it on the COS. Of course, if you've been here for some time and they are not maintaining you, then that means that you've been working and therefore you can maintain yourself on that basis. And so they will need to see evidence of you working here previously. So if you are saying that you are not working, then how then can you show evidence of working here in the UK or your bank statements? It will make it quite difficult. And so if Mr. Markway is listening to us, maybe the best option will be for you to switch to a different employer. I know that it is not easy to come by COSs, but if you can, please do make sure that you switch in good time before your leave expires.
Thank you very much, Lawyer Eunice. Thank you. Our next question is from Nana Etuahene. He is asking, please, if a person is applying as a parent or partner on the 10-year route and has no immigration status, how can they meet the English language requirement?
Okay, so I believe that if somebody is making an application, whether as a parent or as a partner, usually the 10-year route is for those that are not able to meet all of the requirements. And it is because they are not able to meet the immigration status requirement, first of all, or the financial or maintenance requirement and accommodation, or the English language requirement, hence the reason why they are put on the 10-year route. And so if you are not able to meet either of these three requirements or four requirements that I've mentioned, then be rest assured that as long as you meet the relationship requirement for either the parent route or the partner route, you will be granted leave to remain on the 10-year route. So it doesn't really matter whether you've done the English language test or you have a degree which has been confirmed by actors. As long as you are able to meet the relationship requirement, you are likely to be granted leave to remain on the 10-year route. The only reason why the English language requirement will be necessary will be if you want to switch from the 10-year route to the 5-year route in order to slightly reduce the number of years in which you would be going through to qualify for indefinite leave to remain. So I hope I've answered his question.
Thank you very much. Before we take the next question, I would like to remind you that our studio lines are open. You can call 0208 493 7345. I repeat, 0208 493 7345. You can call in to ask your question. We will now take our next question from John Appiah. He's asking, how long does the indefinite leave to remain application process take if the grounds for the application involve emotional and economic abuse? And are there any potential delays or complications I should be aware of?
I'll let Larry Anthony answer this one. This is the topic that she treated, isn't it? So
I don't know.
Sorry, we're having a little bit of an issue. Please,
okay,
Mr. Apia, if you want to get this answer, for example, let me say you can visit BWF solicitors at
yeah.
fourth floor Anna House, 214-218 Tottenham High Road in London. Our postcode is N154NP. There are certain questions that are very delicate. So if you want an answer, you can come to their offices. They are very willing and very ready to help you. Please do not forget to call in to ask your questions. Our very knowledgeable solicitors are ready to answer your questions. We'll have a brief look at the quiz question. which was based on this week's nuggets. Area lives in the UK and has a 4-year-old child, Regina, with Amma Atta. Due to disagreements, they live apart, and Amma initially refused Kwame contact with Regina. A family court in Watford granted Kwame a child arrangement order under the Children Act 1989, allowing him to see Regina twice a week and spend time with him from Friday 3 p.m. to Saturday 3 p.m. Kwame is renewing his leave to remain in the UK as the parent of a British child. His current visa expires tomorrow, and his solicitor has the child arrangement order as evidence of access to Regina. What should the solicitor do to ensure Kwame submits an in-time application while complying with the law regarding the child arrangement order? The possible answers are: 1. Submit the application with the documents, including the court order, as Kwame's visa expires tomorrow. 2. Apply to the Watford Family Court for permission to use the child arrangement order to support his application before submitting. And 3. Submit the application now. Apply to the court for permission to use the child arrangement order on the same day and provide supporting evidence to the Home Office later. This is our quiz question, which was based on a nugget. I shall read the nugget for you just to remind you of what it says. And then shortly, nugget says, when applying for a fee waiver or change in circumstance condition, the Home Office must be satisfied that the third-party support you rely on has provided evidence of their means and income, including 6 months bank statements with explanation of all entries over £100. Most third-party support providers do not appreciate being asked to disclose their private information when they are not the applicant. Therefore, always disclose to the support provider that they will be called upon to provide private information and evidence. This was the decision in SAG and ORS versus Secretary of State for the Home Department. Okay, let's take a short break. When we come back, we shall look at the answers you think are right for our quiz question.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Good evening once again. Welcome to another episode of The Community and the Law, brought to you by BWF Solicitors.
Okay, so as we can see, the quiz has to do with Baba Isifu, a third party supporter who provided a letter for the Home Office explaining the size and the number of people living in her home, and that she could no longer support Kofi Brookman. Baba said that he was not Baba said that she was not prepared to disclose the Mr. Kofi Brookman was not prepared to disclose his personal finances to the Home Office as this was private information. Kofi's application for fee waiver was refused and he contemplated judicial review. What is the likely outcome? As number one, as Isifu did not disclose his financial condition, this affected Kofi's application. Number two, Isifu is a good Samaritan, so he cannot be asked to provide his personal information. And number three, as this is Kofi's application, he does not have to provide Isifu's information. These are the questions to our quiz, and based on our nuggets for this week, we have learned that from the case of SAG and others, it is not uh, irrational or it is not illegal to ask the third party to provide their evidence, such as bank statements or evidence of income in regards to a fee waiver application. So I would like for our viewers to call and to give their best possible answer to this quiz question.
Thank you very much, Lawyer Eunice, for helping us with the quiz question. Apologies, due to some technical difficulties, we had the wrong quiz question. So this is the correct quiz question that Lawyer Eunice has read for us. So we are going to look at the answers that our lovely viewers feel is right to the quiz question. We have Nana Kwame, who believes the answer is 3. As this is Kofi's application, he does not have to provide Isifu's information. We also have Amayebwa, who believes the answer is 1, which is as Isifu did not disclose his financial condition, this affected Kofi's application. We have Kojo Dako, who believes the answer is also 3. We have Ikua Sewa, who believes the answer is 3. At this juncture, we think 3 is winning. Yao Sapong also believes the answer is 3. We also have Abna Nkrumah, who believes the answer is 1. So the race is between 1 and 3. So we've got Kwabna Dakwa, who also believes that the answer is 1. As Isifu did not disclose his financial condition, this affected Kofi's application. Ifwa Tete says the answer is 3. We've also got Kofi Baidu, who believes the answer is 1. So these are the answers you lots or our favorite viewers believe that is the right answer to our quiz question. We are going to go to our Eunice to explain what the question is and give us the answer, and then we are going to see if the ones win or the threes win. So Lawyer Eunice, can you kindly take us through the quiz question and provide us with the right answer, please?
Okay, so Baba Isifu is a third party supporter. So she's the one supporting Mr. Kofi Brookman's application. She provided a letter for the Home Office explaining the size and the number of people living in her home. So she provided a letter. And in the letter, she said that she could no longer support Mr. Kofi Brookman. And she was also saying in her letter that she was not prepared to disclose personal finances to the Home Office as this was private information. So I believe she was able to accommodate Mr. Kofi Brookman, and she wrote in her letter that she was supporting him, but she was not willing to share or disclose her personal information with the Home Office. And so the number three is your answer where was, as this is Kofi's application, he does not have to provide Isifu's information. So going back to our nuggets for this week, we learned that in making an application for fee waiver or an application for change of conditions, the Home Office would usually require you to provide evidence of your income and expenses, as this will help them assess if you are not able to pay for the Home Office fees, and if you believe that your expenses are very high and there is no way that you would be able to maintain yourself and your child or your children, for instance, then they would need to really assess what your income is and what your expenses are, so that there is no abuse, for instance, within the system. And so, those who said number three, that this is Kofi's application and therefore she did not need to disclose. Unfortunately, this is the wrong answer, as we have learned from the case of SAG and others that this information is not something that is unlawful, and it is not something that is irrational to provide. You have to provide these things so that the Home Office can truly assess that Mr. Kofi Brookman is well and truly unable to pay for the Home Office fees, because he's living within Baba Isufu's household. And therefore, because he is living within that household, any support that he's receiving is also counted as some form of income to himself. And so, if he is making an application for fee waiver, they would like to know if his third party support can help him pay for the Home Office fees in one way or the other. And so, unfortunately, he will still need to provide or disclose Barber's information, even though it is not his. So, those who said answer three, unfortunately, your answer is wrong. And for number two, I know that most people didn't go for that, but let's go on and explain what that requires. So, Isifu is a good Samaritan, so she cannot be asked to provide personal information. Of course, we know that she's a good Samaritan, but in this case, she does have to provide personal information in regards to Mr. Kofi Brookman's application for fee waiver, because he has said that she is his um, financial support. And because she has even been willing to provide the Home Office with a letter to say that she supports Mr. Kofi Brookman, in that letter, she states clearly that she's supporting him. So why not provide your bank statements and evidence that you are unable to continue supporting him? So, unfortunately, answer true is also not the answer we are looking for. So the answer will be answer one. It says that as Isifu did not um, obviously disclose the information from Baba, this affected his application. So let's look at the reason why it is answer one. So the Home Office will routinely ask for disclosure of the third party support information if they are supporting you with accompanying food or money. And if they choose not to provide you with any fee waiver, it is because they believe that you have the means to pay the fees. That may mean that there is less compelling case that the applicant is an imminent risk of destitution than would be if the case were that there was positive evidence that the third party was unable to continue providing support. So, in providing that financial evidence that the Home Office is looking for, you are now creating a compelling case that there is no possible way or means by which the applicant will be able to pay for the fees because their third party support is struggling already in their own circumstance, and therefore they cannot provide financial means in terms of the application that the applicant wants to make. And so it is very important that anybody who is providing you with financial support knows that the Home Office will require them to disclose evidence of their income or their financial standing in terms of you making a fee waiver application. So that is our answer for this week's quiz.
Thank you very, very much, Lawyer Eunice. So, as you have it, our answer for this week's quiz is number one. Congratulations to everybody who chose number one. And although most of you chose number three, you have next week as well to redeem yourselves. So, thank you very much once again, Lawyer Eunice, for helping us answer our quiz questions. The answer is number one. Before we come to the end of today's program, we would like to have a quick and brief summary from our very learned solicitor from BWF, Ms. Annie, Lawyer Annie Soa.
Thank you very much, Amela, for all of that. So today the topic was, can I apply for indefinite leave to remain if I am emotionally and economically abused? And the answer is yes. I think, as I said, in society, we tend to think that it's just domestic. When we talk about domestic abuse, it's just physical abuse, but there is so much more. It can be economic abuse, it can be, which is also known as financial abuse, it can be emotional abuse, sexual abuse. You can rely on any of those types of abuse. So if you are a victim of domestic abuse and you're here in the UK based on your partner, so you're in the UK under the partner route, please know that you don't have to die within that relationship. There's a way of escape. You can put in a concession, which is known as the Migrant Victim of Domestic Abuse Concession, which can be found online. And then you will have 3 months leave, which is separate from your partner. You can also include your children under that concession. And then within those 3 months, you can either switch to a different route if one is applicable, or you can put in the ZDV application, or you can decide to leave the UK. Today, we looked at the validity requirements for a ZDV application, the suitability requirements, and also the relationship requirements. And we also looked at the evidence. So you have to make sure that when you put in such an application, that you have a strong case. If you have police reports or letters from the NHS or your GP, add all of those. If you have pictures of your physical abuse, pictures of bruises, cuts, broken arms, any type of evidence that you have, even if it's threatening text messages, you can rely on all of those to help with your application, and it should be fine. In terms of the standard service time, how it works is that it would normally take at least 6 months for your application to be decided. So I do hope that this helps someone. If you know someone who is in such a situation, please share this program with them. We're here to help the community, and so that is exactly what we're trying to do. Thank you so much for joining us today, and have a lovely, lovely weekend. Thank you.
Thank you very much, Lawyer Annie. Lawyer Eunice, do you have any last words for our lovely viewers?
So, as always, we thank you also for coming to join us to make the program a success. We are here to obviously help in terms of any issues or matters that you may have. Our address and telephone numbers have been listed very nicely by Sandra Fraser. Our producer will also put that on the screen. We open our offices from Monday to Friday from 9:30 a.m. to 6 p.m. every Monday to Friday. As the Christmas holidays are coming, there will be bank holidays that we will have off. But apart from those, we are always here to help you in terms of your legal matters. We hope to see you sometime, same time next week.
Thank you. Thank you very much, Lawyer Eunice. So, as we have all learned here today, it is possible to apply for indefinite leave to remain if you have been a victim of domestic abuse. Lawyer Annie has also explained to you that domestic abuse is not just physical or emotional, it can also be financial. So, if you know anybody, or if even if you yourself are in a domestic abusive relationship, please note that it is not the end of you and that you can apply for indefinite leave to remain, not only just for you, but for your child as well. Please also do not forget that BWF solicitors are very willing and very happy to attend to any legal matters you have. They are located on the fourth floor of Anna House, 214 to 218 Tottenham High Road in London. The postcode is N154NP. Their opening hours are from 9:30 a.m. to 6 p.m. So you could call the office number to book an appointment. You could also walk in and they'll be very happy to attend to any legal issues you have. This has been the Community and the Law. I have been Pamela Oakley. We have had very learned solicitors, Lawyer Eunice and Lawyer Annie here today to help us with this very interesting topic. I hope it has helped many of you, and I hope many of you or all of you will share this with your family and your friends to help them to learn with us what we have discussed here today. See you same time next week. Thank you for joining us and have a very blessed week. Bye.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.